Yes. Anyone? Second phase who have joined?
Yes, sir. Myself, Sachin Prasad, sir.
Yeah, good. Sachin, can you introduce yourself?
Sir,
Why
I
did
am
you
B.
join
Sachin
now?
Prasad, sir.
Yeah, good. Why do you want to do law?
I completed my, sir. I want to give justice to poor people, sir. Why? Because there are so many people who didn't get justice, sir.
Do you think law, joining law, you
Just
can do
want to
justice?
give justice to them.
Justice is a matter of judiciary. So probably after you complete law, you have one more task. That is, you have to be select for judiciary.
Yes, sir.
Delivering
Exams
of
are there
justice.
now, sir.
Yeah. So good. Nice job. Nice talking to you. Okay.
Thank you, sir.
Well, welcome. Okay. So for the second phase students, probably you are in the mid, almost we have completed 6, 7 topics on probably law of thought. So how you cope up, you have to find, you start reading. If you don't understand anything, please do ask me. Okay. So we here, as on today, we are talking about the law of torts, which are, I will give you a general explanation on law of torts, where probably it is a civil wrong in the sense uh, it is not totally the public wrong, not the private wrong. Public wrongs are usually understood to be crimes defined by the state. Okay, and state also has some responsibility towards individuals. Okay, so that individuals is reacts when their legal rights are violated, when there are some legal rights which are being violated. Okay, so probably not to each and every issue. State has also got some immunity in the sense protection probably maybe in the form of statutory immunity. That is, you might have come across when state is trying to take away land from individual for the public purpose. That is probably extension of roads, laying of railway tracks, and the officers who are assisting, like the deputy commissioner of police. Okay, in executing the orders of the collector, probably he uses force. There will be some kind of probably injuries or whatever. So in such cases, you cannot have law of torts. Okay, they have got an immunity, they have got a protection. They are performing their duty. It is not breach of duty, but it is performance of a duty. So when there is a breach of duty, probably you may think the malicious prosecution. See, for what do you understand by malicious prosecution? Malicious in the sense something wrongful, that is something injury, damage, legal damage to you all, maybe The malicious prosecution is a concept. Okay. Okay. So yesterday we have studied about the vicarious. We are continuing with the liability. How liability, to what liabilities we are entitled for damages. Okay, civil wrongs. You can only be, you can only claim probably the damages. The damages already you have studied about the two magazines, that is Injurious Sign Damno and Damnum Sign Injuria. Okay, injury without damage. So when there is no damage, there will be damage. You cannot find the physical damage, but there will be some legal right which has been violated, that has been restricted. Okay, so based on that violation of some legal right, so the basic principle, that is UB just ibi remedium, it says that where there is a right, there has to be a remedy. Based on this principle only, basic fundamental principle which the law of torts has evolved. Okay, so now today we are coming across certain liabilities. Okay, different aspects involved with probably you may take it as nuisance, trespass, and then nervous shock. All these aspects are a part of some specific torts. Okay, so moving forward, just a moment. Some more people are getting admitted. We have to probably wait for starting this doctrine of strict liability. Uh, Hello.
Hello,
Yes.
sir. Marwadi Parishad College, sir.
అవును సార్.
సార్ ఈ మేనేజ్మెంట్ కోటా సీట్స్ ఉన్నాయని చెప్పారు కదా సార్.
ఎవరు చెప్పారు?
లాస్ట్ టైం వచ్చాను అంటే 2 days కాల్ చేయమని చెప్పారు.
అదే ప్రాబబ్లీ ఏదైనా అడ్జస్ట్మెంట్ ఉంటే 90% అబవ్ ఉంటేనే డిగ్రీ వాళ్ళకి ఇవ్వమని చెప్పారు మా మేనేజ్మెంట్.
ఏంటంటే
90% ఉంటేనే ఇవ్వమని చెప్పారు.
చూడు ఎంత 75% సార్.
90 మరి వాళ్ళు చెప్పింది నేనేం చేయలేదు. ఓకే,
చూడండి సార్ ఒక్కసారి మన అవకాశం
చెప్పలేము. ఓకే
సార్.
అదే 90% ఉంటే చెప్పండి, సీట్స్ ఇస్తారు అని అన్నారు. అంటే ఇప్పుడు కాంపిటీషన్ ఎక్కువ ఉంది కాబట్టి అది పెట్టారు, అది మనం ఏం చేయలేదు.
అవునా?
చాలా రైట్ మా. So probably, yeah, we shall go move with the concept of the strict liability. Liability is responsibility. Probably it may be in the form of duty, responsibility. Father has got sons, children's responsibility, parentage responsibilities. Wherever you come across the word responsibility, you may have that is individual has also got responsibility towards other individual as well as towards the entire world. Okay, so probably you see you can enjoy your liberty as long as you don't harm others. So that is your individual freedom. That is the freedom which is being given by the state for an individual. So you can enjoy your freedom as long as you don't harm any other individual. The the responsibility, the concept of strict liability is also known as no fault liability. Okay, no fault liability. Okay, so I will put it here just a moment. It is also known as also known as hello అవునా కూర్చోమని నేను కొంచెం నాకు 2 క్లాసులు ఉన్నాయి ఇప్పుడు కరెక్ట్గా 1 తర్వాత వచ్చి నేను అది ఇస్తా అన్నాడు సార్. అలా స్టార్ట్ అయిపోయిందన్నా మళ్ళీ మేడం పరిచయం చేస్తాను. So it is also known as strict no fault liability, where see here we are talking about a liability for some kind of harm done to others. But the problem here is this concept when you are looking at you talk about no fault liability. So the problem here is the concept clearly says that whenever there is some fault, that fault has to be made liable. You are getting the point, okay? You are simple. See, for us to understand that concept, no fault liability. So for no fault of us, are we being made liable? Liable for what? Is the simple question. Okay, so this concept evolved during 18th century when British was ruling India. So there were situations when a person may be liable to be made liable for some harm, even though he is not negligent in causing the same. So even though if we are not negligent in causing some sort of act or omission, or there is no intention to cause harm, then also we will be made responsible. Responsible for what? Responsible for some kind of loss, some kind of damage. So in situations when a person, he has to be made liable because even though there is no fault, okay, so of some positive efforts to avoid the issue, okay. So law recognizes no fault liability. So even though there is no fault of any individual, there is some kind of harm, loss. Okay.
Sir, can you give some example for this?
Loss. Sorry.
Can you please give some example for this?
Yeah. I am proceeding. See, when we come clearly, see this, how we have to understand how this concept has evolved. So the basic fundamental concept, the evolution of the concept, if you look at And because it has come through a decision of House of Lords. So Blackburn, who was the judge at that particular time in case law, that is R versus Fletcher, that is in a case law, they evolved a strict liability principle. I would like to just a moment. Some people are still getting. This is the basic case law, out of which that is the principal doctrine of the strict liability which has evolved. So the example, that is strict liability principle, you know, it is also called for no fault. So probably in certain cases when we have no fault, but still there is certain kind of harm. So how do we address that harm was the principle on, that is just equity and good conscience. Out of those principles it has come out. So the general principle of negligence in torts, where person can be held liable for commission of a tort only when the plaintiff can prove negligence on his part and the defendant himself is unable to disprove it. So until, usually in burden of proof, plaintiff has to establish the burden. Huh?
యాడ్ చేయండి.
ఏంటి మేడం?
ఫస్ట్ సెమిస్టర్లో ఈ 2 నంబర్స్ యాడ్ చేయండి.
2 numbers చేశాను. ఇప్పుడు ఏమంటారా? ఒక్క నిమిషం, జస్ట్ మూమెంట్. ఐ నీడ్ టు యాడ్.
మీరు అడ్మిన్
అట్లా కాదు, మీరు కూడా ఉండండి అడ్మిన్. అట్లా కాదు, ఇట్లా యాడ్ చేసేటప్పుడు వాళ్ళకి పర్మిషన్ ఇవ్వదు. ఒక్క నిమిషం వాళ్ళకి.
స్టాలిన్ శివ సార్ మ్యూట్లో ఉన్నప్పుడు మనం మాట్లాడుకోవచ్చు కదా. బా చాలా సీరియస్ ఉన్నాడు అబ్బా అంతా.
Probably we have the newcomers are joining second phase, and we are okay. So the strict liability principle is also known as no fault principle. It has evolved from the case law, that is during the 18th century when British was ruling us. We understood that this law of torts has come out, has evolved from the judgments of the Privy Council. Privy Council is that particular point of time when the courts, the issue, that is Supreme Court, for your reference, the present Supreme Court was known as the Privy Council, but the control Privy Council was deciding in the England. So British, they made those principles. Okay, so this was evolved from R versus Fletcher, that is Ryland versus Fletcher, in the House of Lords, that is when they were ruling in India in the 18th century. So what does this principle, this doctrine of strict liability speak about, which is no fault liability? See, even though an individual does not do any act, but because of that particular circumstance, act, the other individual is subjected to loss or harm. So the state has to address. So in this general, in this, usually when there is harm, whose negligence is a concept which comes up. But no fault liability, but they are made liable. Why? This is explained in this case law. So even though when there is no fault of uh, that is Fletcher, that is defendant, he is made liable for what? Let us examine in this case law. Okay. So the facts of this case is that Rayland, who is a plaintiff, is a owner of mines, coal mines, and Fletcher, his neighbor, is a person who had a mill, and to run his day-to-day activities of the mill, he wanted energy. That is energy. That is probably the electricity to run his huge electricity to run his mill. So he plans that. So he wants to build a reservoir in his area, in his land. So both being neighbors are that is Ryland versus Fletcher. So Fletcher wants to build a reservoir. Reservoir is you know that huge where they try to generate certain kind of electricity. Okay, so probably Fletcher in his land he has given a contract to independent individuals, that is independent contractor, for him and an engineer, independent engineer, to build a reservoir in his area. So probably the independent contractor has built a reservoir on the land overlooking certain kinds of shafts which already were underneath the land. Okay, so certain kinds of shafts were underneath the land. So probably this Fletcher has started filling the reservoir with water. So what happened? That because of this shafts underneath, the water which he was trying to fill it in the reservoir entered into the Reliance land, coal mine entered into the coal mine of Reliance and destructing his property. So he filed a suit on Fletcher. Here, in this, usually what happens is, it is the burden of proof usually lies on plaintiff usually in all cases. But here, the burden of proof in such cases, in strict liability, lies on the defendant. Okay, so he has to prove that there was no fault from his side. Okay, so but in regular cases, in general cases, the burden of proof lies on the plaintiff, the person who is trying to move the suit. Okay, who is trying to litigate it or bring the litigation. Here, usually in strict liability, this is the speciality of strict liability. It will be on the defendant, that is Fletcher. He says he has to escape from the liability. He has to clearly establish that there was no fault of mine, because in his defense, the Fletcher has brought forward that it was the independent contractor whom he has given the contract has built that reservoir, and he has no knowledge about what expertise that independent contractor and the engineer has brought forward. So here the case in this case law, the judge who was looking into this R versus Fletcher case has pointed out certain conditions to establish the this concept of strict liability. So, to establish this concept of strict liability, that Blackburn judge, who was at that particular time deciding this case, has put forward certain conditions, three conditions. That is, the first condition is dangerous thing. Dangerous thing. How do you look at this dangerous thing on his land? What was the dangerous thing on his land? It was the reservoir with water. And then the second condition he said was that dangerous thing was on his land. So he took what mistake had made that particular affect the petitioner, that is the plaintiff, sorry. So so what was that see, it was, if it is within his four walls, which is four walls of the Fletcher, that is defendant, it would have been no fault, he would have been in no fault. But the water from the Fletcher's land has through shafts have entered into the coal mine of Leland. So the water, when it skipped, that mistake, that escape of water from his land to another's property is the main cause. When these two things, the dangerous thing and escape, are given, explained by the petitioner, probably the doctrine of strict liability will come into effect. Okay, so the thing just, it cannot escape it. So this escape has to be clearly understood in the case law. Okay, for no fault liability. Okay, so natural use of land. Probably third thing is the natural use. See, how do you understand the natural use? See, dangerous thing keeping in your land probably may be a kind of thing, but when it is causing loss to other individual, probably there lies a doctrine of strict liability. So until your four corners of your land, of that Fletcher's land, probably there was no liability. He can maintain that, but it is not a natural thing. It is a foreign object which he is trying to get. He is trying to build a reservoir on that. It is not natural. It is not naturally grown tree. It is not naturally, the land is natural on which trees grow. All these things happen. So it is non-natural. Any non-natural use of land, that is, building a reservoir is a non-natural use of land. So hence, that Judge Blackburn has clearly, basing on these three essential conditions, if these three conditions existed, he termed it to be a doctrine of strict liability. And recently, I would like to bring to your notice, you have come across the NGT tribunal. NGT, what is that?
National Green Tribunal.
Hear me?
National Green Tribunal, sir.
Green Tribunal.
Yeah. So National Green Tribunal, okay, has given one recent. There was a recent mishap. Might have already read in the paper also about the company which they collected 50 crores. I remember only few facts on this. Probably in Chennai, Tamil Nadu, Chennai. Can you elaborate? Anyone can elaborate? NGT, state liability, some cause of harm by some enterprise. LG Polymers. They were supposed to deposit 50 crores for some kind of harm caused to their employees. Did you heard about this? I cannot elaborate the complete picture, but I remember this was a kind of strict liability which NGT has imposed. No fault. They were trying to escape with no fault theory. But see, that is how we would. The courts wanted to bring. See, this concept was brought in the 18th century when there were no advanced industries. Now the concept, as the society is dynamic, it is changing. There has to be someone who is supposed to be made liable for the harm. So the concept of strict liability has got restriction, and the recent one, that is after Union Carbide Company in Bhopal gas leak case, the concept has extended, the strict liability has extended to absolute liability, the doctrine of absolute liability. Okay, why it has extended to doctrine of absolute liability? What exceptions does the defendant have to escape from that loss? Escape, even though whether he is trying to do certain kind of harm, he has got certain exceptions under strict liability. Yes, are you able to understand? Anyone? Any doubts?
No.
Are you able to understand? Am I clear?
Yes.
Okay, so strict liability was the 18th century outcome, and as the society is changing, and what exceptions the strict liability has got made the outcome of the uh, absolute liability. That was after Union Carbide Company's issue with the Sriram Foods in Delhi. MC Mehta versus Union of India has evolved a new principle, that is absolute liability. Why they have to evolve? Because there were exceptions to strict liability. Exceptions in the sense, the individual who is probably cause for harm is trying to escape through these exceptions. The Blackburn has given certain exceptions in strict liability where they can have no fault for, even though they are causing the loss. Okay, so those are the exceptions of strict liability made is an outcome for absolute liability. Okay, so what are the exceptions we will have? We'll have five. There are absolutely five exceptions. Exceptions is, first one is voluntary non-fit injuria. Okay, let me just put it on the web. We are trying to get exception. Voluntary non-fit injuria. So here, this is the what does this say? This is a concern. See, when mutual, probably you may think about mutual concern. When two individuals try and come to an understanding, settlement, and do, and further, those there cannot be liability. They cannot, because they cannot be subject to that particular harm. Okay, that is voluntary non-fit injuria, that is concern of the plaintiff. So whenever, see, there is no case, there is no when plaintiff has either expressed or implicitly consented to the presence of source of danger, and also there has been no negligence on defendant's part. Okay, so both coming to an understanding, there cannot be any sort of liability between them both because they have come to a mutual consent. Okay, so
Sir,
second,
what is voluntary here? Is it voluntary?
voluntary. They are expressing their concern.
Okay.
They are giving their concern.
By self.
Voluntary, they are accepting to the harm.
Okay.
Okay, injury. Okay, so here probably, the Sriram Foods that is MC Mehta versus Union of India is the concept evolution for absolute liability. That is probably because of these exceptions, the new concept has come out. So the second one is the plaintiff's own default. When damage is caused to the plaintiff solely due to his own fault, probably there was some notice, he would have not done that. He shall receive no remedy in such cases when there is plaintiff's own default. So when he is supposed to do something, he doesn't do that, then probably it is his own. Yes. Okay. Third one is act of God. That is, what do you mean by act of God?
Natural disasters.
Any natural disaster? Yes.
Earthquakes.
Earthquakes, anything.
Anything related to natural disaster.
Yeah, for that also the damages, the losses, we cannot claim across. And next is the statutory authority. As I have told you, when they are trying to perform their duty, the state gives immunity. The acts done under authorization of the law, statute of the government, state government, causes any damage to any person, it acts as defense to the action of torts. They have got immunity. So their actions cannot be made liable. They skip over the liability. They say simply it is the government duty which we are performing. So hence there cannot be any sort of remedy for the immunity, state's immunity. They are.
So what is the fourth one, sir? State's immunity.
Sorry?
What is the fourth exception called?
Act of God.
That's the third one, no?
Third one is act of God. I'll repeat. One is voluntary non-fit injury, that is mutual consent, plaintiff's own default. Then the third one probably I might have said act of God. The fourth one is statutory authority. The fifth one now common benefit of plaintiff and defendant. So if they have any common benefit, both when the act of or escape of a dangerous thing was for a common benefit of both defendant and plaintiff, there cannot be any sort of liability. And the fifth one, the concept of the accident probably will have certain accidental, that is probably without no intention. When they have accidentally happened, so usually what happens was when there was because of these exceptions, they used to escape the liability within the law. So they probably if there is harm, there is loss, if they establish that without my knowledge, the things has happened. So probably they would skip the liability. They would skip. The defendant would simply shift the liability towards the state, stating that I am protected and I need not pay any damages. So, because of this escape by the defendant, there has a concept which has evolved, that is the absolute liability. And with this, probably we will take absolute liability tomorrow, because you know that it is a big concept, and probably I'm running short of time. Uh, we will see that in the next session about the absolute liability. Absolute liability, which is which has evolved, is a concept of the 19th century. That is the recent one. The recent one, because of the judicial principles which has come out, is an outcome of the present. Okay, probably if you have any questions, you may ask. No.
Sir, any illegal activity done by our tenant. In this case, the plaintiff is also held liable.
See, what kind of illegality you have to
Like
clear?
smuggling drugs.
Public wrong, private wrong.
Sorry, sir.
Private wrong or public wrong?
Public wrong.
Then FIR. You also seek damage. You have, what is the loss? Damage.
Is liable, sir, public means?
Sorry? Damage. Both public wrong as well as private civil wrong. Both you can bring. Tell me, madam, what is that private wrong? Public wrong, crime, you register FIR. Second thing is private wrong. What is that private wrong? Damage for remedy.
Reputation.
Sorry? Defamation, yes.
Reputation. Private law.
Yes. If defamation is law of torts, you have got
Yes, sir.
remedy.
Breach of trust.
Yeah. So in this case, the plaintiff is held liable.
Yes, absolutely. You defendant, you have to issue notice immediately, mentioning about that FIR also registered. That is the piece of evidence.
Okay.
Issue legal notice.
Yes, sir.
And what is the loss damage to your reputation? Establish. You see, assessment of damage is also there. You wanted more damage, so you have to establish to what extent. That is it. 1 lakh, 2 lakh, 3 lakh, 10 lakhs. You want?
Okay, sir. Thank you.
Okay. Anyone else?
Sir, just repeat the fifth exception in the strict liability.
In strict liability,
Fifth, last exception.
common benefit of plaintiff and both are having some benefit.
Okay, common benefits. Okay.
Yeah. Yes. Anything else? Did you understand the concept? Strict liability. This you will come across many things. This is a key. This is a prime doctrine of strict liability, is a important concept in law of torts. You heard about this LG Polymers issue in Chennai? They deposited 50 crores for some damage to the environment.
Was it in Chennai or Vizag?
I don't probably remember that. Probably
Because in
maybe,
Vizag also we
Vizag,
had
Vizag.
LG.
maybe
LG
Vizag also.
Polymers.
Yeah, it was in
So,
Vizag.
It's in Vizag,
sorry,
LG Polymers.
sorry.
Last year, May,
It's Sterlite,
I
sorry.
believe.
There was one more, Sterlite in Chennai.
Okay.
Incident in Chennai. Probably I am confused with both.
Okay. Sir, when you are speaking about R versus Fletcher, I had a question like, for example, in my land, I have grown a banyan tree from years, and the other one beside my land has started constructing his house. And after like 5 years, he wanted to file a case that because of my tree, the roots of the banyan tree will be too long, right? The foundation of his house is damaged. So in this case, can he file a complaint against the tree that I'm growing in my land?
Natural. It is natural thing. You are not connected with that tree, right? No fault of yours.
But it's in my
See,
land now. So if he asks me to
your
cut down,
cut down tree, there is no fault. You can escape no fault.
okay,
No fault theory.
no fault yet.
See, it
Okay,
is not. See, you are not trying to extend those roots into his land, right?
exactly.
The simple escape is that not natural.
Okay,
It is a natural thing which tree is growing.
Yeah, it's a natural.
okay.
Got it?
Yeah, yeah, got it.
No fault. No fault. Yes. If it is a non-natural use of land, then probably you will have a liability, strict liability will come to your.
Okay, understood, sir. Thank you.
Okay. So we'll stop for today. We shall meet in the next session. Thank you all.
Thank you, sir.
Sir will be coming.
Thank you,
Sir will
sir.
be coming.
Thank
Thank you. Wait for this.
Now, which lecture we have?
Sandeep sir is coming. Wait. You all wait in this.
Okay, sir.